Okay, hello, CRSE students. This is Sam Zakarian with the one of the instructors for the Chicago Real Estate School, continuing with our videos on the chapters. We're going to start off with chapter 16. This is actually our final chapter. This is going to be done in two parts. So again, just make sure I'm going to follow with the 10th edition. And if any of you have any questions, always talk to your instructor. So we are starting off on page 260. Now, this particular chapter deals with Illinois law. You will have 45 questions on a state portion dealing with Illinois law, which is primarily chapter 16, but also chapters 11 and 13 will also included in that. And so a lot of things will be duplicated. So on the very first paragraph, just want to let you know that Illinois had real estate licensing laws since 1921, so well over 100 years. And the purpose of Illinois real estate licensing laws is to evaluate the competency of people engaged in a real estate business for the protection of the public, Now, if we skip down to about 5 paragraphs, they talk about the different departments. Now, we are licensed by what's called IDFPR out of Springfield. So let me get to my chalkboard. I want to point out something to you. Just getting in there right away. So just bear with me. Okay. So again, we are licensed by IDFPR. Stands for Illinois Department of Financial and Professional Regulation. Now, not only does IDFPR regulate the real estate industry, there are well over 300 licenses, doctors, nurses, attorneys, just about anyone that needs a license in Illinois are under IDFPR. But the real estate portion of IDFPR has grown quite large. And what they have now is they created a separate division under IDFPR just for the real estate, and the initials are DPR, which stands for Division of Professional Regulation. Now, both of these are referred to as the department. We call them the department. So now, the department basically they implement the laws, License Act 2000. They enforce any violations, and these are what the rules that we all have to follow as licensed agents. Now, department through the division, this is towards the very bottom of this page of 260. The department through the division of professional regulations has a primary authority to administer the Illinois Real Estate License Act of 2000. These are the rules that we follow, and also empowered to issue the rules and regulations that implement and interpret the act. Now, the department, the very last line, it says the department is responsible for administering such activities, such as, let's go to page 261. Those 4 bullets at the very top, make sure you understand them. Conducting license exams, issuing and renewing licenses, preparing all forms, and collecting the fees. Now, the department has additional functions, and they include the next 3 bullets. They conduct hearings, they impose penalties, and they restore suspended or revoked licenses. Now, the governor of Illinois appoints what's called a real estate coordinator and a deputy coordinator. Now, some of the functions as the real estate coordinator, there's 5 bullets underneath. You can go over those yourself. But the second one is the one I would pay a little bit more attention to. One of the duties of the coordinators being a direct liaison between the department, real estate profession, real estate organizations, and associations. Now, the very next paragraph I want you to highlight, there is a disciplinary board. If anyone has been aggrieved by a real estate licensee, they can file a complaint with the disciplinary board. Now, the disciplinary board will investigate any written verifiable complaint against any licensee. What's important is knowing the composition of the board. So at the very bottom of page 261, they talk about the board, those couple bullets there you can highlight, and also there's some more on 263. But let me go over these with you. The board is made up of 15 members. All 15 members must be U.S. citizens and Illinois residents for at least 6 years. Of the 15, 12 of them must be licensed real estate brokers or managing brokers who've been licensed for at least 10 years. Then there's 3 members that are also serving on this board that they're not licensed, their immediate family's not licensed, they have nothing to do with real estate. That's the composition of the board, and I want you to be a little bit familiar with that. Now, about 2/3 of the way down, still on page 262, they talk about obtaining and keeping a real estate license. So, who needs a real estate license? I'd like you to highlight these bullets at the very bottom of this page, and I believe there's a few more on top of the next page. Yes, there is. Basically, who needs a license? Anyone that lists, sells, trades, exchanges, any real estate activity for compensation or expectation of compensation, they must be licensed. Now, a fairly new law just came out a couple years ago about wholesaling, and you can highlight those 3 paragraphs on wholesaling. Wholesaling, now you need a license. You need at least a broker's license to do wholesaling. Now, wholesaling is that, let's say I would buy a property from someone, and then I will sell that property before I even close on it with the original buyer. I sell it to someone else. That's wholesaling. You need a real estate broker's license for wholesaling now. Unlicensed Agent Act. You can highlight, put an X by that. IDFPR has a right to investigate anyone that's licensed or unlicensed, and they could even impose penalties against people who are unlicensed who happens to sell real estate. Now, again, in order to sell real estate, you must have a broker's license, a managing broker's license, or if you're going to be leasing residential property, you need a residential leasing agent license. But there are exceptions to being licensed and selling real estate, and that's towards the bottom here of page 263. I'd like you to actually highlight and actually put X's by all these bullets. So let me go over these with you. The first bullet, owners or lessors. If you own your own property, you're the owner. You do not need a license to sell your own property. You do not need a license to lease your own property. The second bullet, acting under duly executed recorded power of attorney So if I signed a power of attorney over to you, you can sign my name to anything, even sell my real estate. The next bullet, services rendered by attorney at law while performing duties as a lawyer. They do not need to be licensed. The last bullet on this page, any person acting as a receiver, trustee, and a bankruptcy administrator, executor, or guardian, or while under a court order or under the authority of a will, they do not need a license. Let me take a moment to explain that. Let's say you have a relative of yours that passed away, and you're the executor of their estate. And it's part of your duties to dispose of that property. You do not need a license in order to do so because you're acting under the authority of a will. On top of page 264, this one, I'd like you to put a couple X's by it. I want you to remember a resident property manager. A resident property manager is someone who lives in a building that they manage. You do not need a license if you live in that particular building that you manage. Otherwise, you do. But you can only manage that one building that you live in, resident property manager. Actually, put a couple X's by the next bullet, too. If you work for the state of Illinois or you work for the federal government and your job is to acquire and dispose of real estate, you do not need a license to do so, but only in the performance of your job. Doesn't mean on your day off you can go and sell your neighbor's home. Let me give you a couple quick examples. You work for the federal government, and your job is to acquire and dispose of United States Post Office location. That's your job. You do not need a license in order to do so. Let's say you work for the state of Illinois Conservation Department. Your job is to acquire and dispose of parkland for the state of Illinois. You do not need a license in order to do so because that's part of your job. Now, remember, that's only for the federal government and the state of Illinois. Now, if you work for the city of Chicago, you work for Cook County, and your job is to acquire and dispose of sites, you must be a licensed broker or managing broker, or they have to hire someone. You work for a Chicago public school system. You're supposed to acquire and dispose of locations for schools. You must be licensed, or you must hire a licensee. So remember, it's only for the state of Illinois and the federal government that you're exempt in the performance of your job only. Now, this next couple bullets here, resident lessee. Now, if you live in a building, you are allowed to help the owner lease apartments. You're allowed to do up to 3 apartments a year, 3 of them. And you are allowed to collect a fee, but no more than $5,000 or 2 months of your own rent, whichever it happens to be greater. And you're only allowed to do that in every 12-month period. So make sure you go for that or understand that. Now, there are 3 licenses that exist, and I believe that all of you on listening to this video are going for your real estate broker's license. So now a broker's license, the license that you're going for as a real estate broker, allows you to list, sell, and lease any type of property, whether residential, commercial, agricultural, special purpose properties. That's what your license allows you to do. You must work for a sponsoring broker. You must work for a sponsoring broker. Now, the requirements in order to get a real estate broker's license, towards the bottom of this page 262, you must be at least 18 years old. Next bullet, you must be of good moral character. The very next bullet, you need a high school diploma or GED. You must prove that you have completed 75 hours of actual classroom instruction, class instruction with a approved school in the state of Illinois. And you must pass the written exam, the state exam. Then there's a couple other bullets on top of page 265 where you have to get find a sponsoring broker, and they kind of tell you a little bit about what the state exam is all about. Now, after that set of bullets, the second license that exists out there is called a managing broker's license. You must have a managing broker's license if you wanted to be a sponsoring broker and open up your own office. You need a managing broker's license if you wanted to get a designated managing broker's position within a real estate office, and you need a managing broker's license if you want to manage property for someone else. Now, the requirements for a managing broker's license, you must be at least 20 years old. You must, next bullet, you must be a good moral character. Now, the next bullet, you can put an X by. You must be licensed as a real estate broker for at least 2 out of the last 3 years. You need a total of 165 hours of education in order to get your managing broker's license. Now, just to let you know, let me go on to a new screen. I want to just point out something to you. Up right now. Now, all of you are taking the pre-license course right now. This is called the broker's pre-licensing. Now, in order to take the state exam, to qualify for the state exam, to get your real estate broker's license, you need a total of 75 hours of coursework. Of that 75 hours of coursework, 15 hours needs to be actual classroom. Now, on your first renewal, your very first renewal, you are going to need an additional 45 hours of what they call post brokers. So the post brokers, of course, and this is going to be on your first renewal. Because once you pass the state exam, once you complete this course, you can start selling real estate immediately. But on your very first renewal, which I'm going to talk about later on in this chapter, when your license fees come up, renewal time, you need an additional 45 hours. This is only on the very first time you renew your license. 45 hours of additional coursework. Of that 45 hours, 15 hours has to be classroom or live webinar. Now, you don't test with the state on a post brokers. You do test with the school, and this is offered through our school. When that time comes up, you'll be notified of it. Now, in order to get a managing broker's license, and again, you need a managing broker's license. If you want to open up your own office, if you want to manage an office, if you want to manage property for others, you need a managing broker's license. Now, managing brokers require you to have 165 hours of coursework. Now, again, you cannot go for your managing broker's license unless you've been licensed for at least 2 out of the last 3 years. Now, just to let you know something, go back to the left here. You have 75 hours they're going to have completed as a broker. Then your post brokers on your first renewal is another 45 hours. The 75 hours and the 45 hours will equal 120 hours. That gives you 120 hours, which is applied towards your managing brokers course. Now you need 45 additional hours of coursework to get your managing broker's license. Of that, you got to have at least 15 hours of classroom. And that's going to give you, and you have to take and pass the state exam. So that's your managing broker's requirement. Now, let's go on to the very last paragraph here on page 265. Education exemptions for brokers and managing brokers. Now, attorneys, licensed attorneys in Illinois, they do not have to take the actual classroom. They do have to take the broker's exam and the managing broker's exam. They take the broker's exam, they're licensed as a broker for at least 2 or 3 years, then they could take the exam for the managing broker's license, but you have to be an attorney and they will waive the actual classroom hours for them. Now, let's go on to page 266. Let's go on to, here I want to point out something at the very top of page 262. Continue eligibility for brokers and managing brokers. So that very first paragraph there, that once you complete the course here with the school, you have 2 years to take the state exam. Once you complete the course here with us, you have 2 years to take the state exam. Now, I'm giving you some advice, and please heed this information. Do not wait 2 years to take the state exam because you're not going to remember this information. I highly recommend that you take the state exam within 1 or 2 weeks once you complete the course. Don't wait. You're not going to remember this information. I know you're taking a course, it's 4 or 5 week course, and then sometimes you want to just take a couple of months off and enjoy. Problem is you're going to forget this information. You committed yourself to these 4 to 5 weeks with us. Do yourself a favor. Take a couple extra days, study up, schedule this state exam, and pass the state exam. Okay. Now that next paragraph, you can highlight, put an X by, and I want you to understand this. Now, the coursework is good for 2 years, but if you take the state exam and you don't pass, you still have 3 other chances to take the state exam. But you got to do that within a 1-year period. So you took the state exam, let's just say, I'm going to give you a date, on January 1st, and you did not pass. Even though the coursework is good for 2 years, but the clock starts ticking at that point, and you must pass the state exam within exactly 1 year of the first time you took the state exam. A lot of mistakes that some students make. Well, the coursework's good for 2 years. I didn't pass. I study up, but if they come back after a year, they're going to have to retake the entire course. So please understand that. And if you have any questions, please you contact the school or talk to your instructor. Now, the third license that exists out there is about 2/3 of the way down on 266 is called a residential leasing agent license. Now, a residential leasing agent is a very limited scope license. Just allows that person with that particular license to engage in leasing residential property. They cannot sell property. They cannot list property for sale. They cannot lease any type of commercial or industrial. They can only lease residential property like apartments and things like that. Now, they have the requirements. You can go over that on your own. But one thing I do want to point out on top of page 267 is period in which to obtain a residential leasing agent license. So I want you to highlight, put an X by that. I want you to know this. Now, a person can work as a residential leasing agent for 120 consecutive days as long as they are pursuing their leasing agent license and they're working under the supervision of a sponsoring broker. Now, again, just like a real estate broker, leasing agents must also work for a sponsoring broker. Now, requirements to take the state exam, which is on the bottom half here. I'd like you to go over all of these right here, but starting with the 8th bullet down and continuing, I like to put X's by them, highlight all of them. But the first one, I want to go starting with the 8th bullet down. It says, score reports will be emailed to the candidate after the exam. So they'll let you know your results as soon as you take the exam, but they're going to email them. They're not going to give you a hard copy anymore. Passing candidates will also receive a license application with instructions how to activate your license, but you cannot do that without a sponsoring broker. The next bullet, passing candidates will have 1 year to apply for your license. Okay, say you pass the state exam today. You have 1 year to activate your license to be placed with the sponsoring broker. Next bullet, candidates who fail one portion of the exam, they only have to retest on the portion that they failed. But after 4 failures, you have to redo the course and retake all the exams again. Let's go on to, by the way, if you pass, they will not give you your score if you pass. They only give you your score if you fail, and they tell you kind of where your weaknesses were. So on top of page 268, that first bullet, I already mentioned that to you. After 4 failures, you have to retake the course again. And then it starts all over with the 4 chances again. The next paragraph, the real estate license. After passing the state exam, applicants will receive a score report, and then you are required to apply for your license with a sponsoring broker, and the state will give you your broker's license. Now, next section. Once a broker company has been selected by the person who passed the state exam, you can highlight these 5 bullets. They apply for the license. They have to have a sponsoring broker. And then whether you're you're going for, all of you are going for your broker's license. So, and you get a copy of your license. One of the main licenses, a 3x5 copy of your license, is kept with your sponsoring broker on display in their office. You get a wallet size copy that you keep with you. It could be a hard copy, or you could take a photograph of it and keep it on your phone. But you must carry, it's called a pocket card. You must carry that pocket card with you at all times whenever you're engaged in the real estate business. Now, the next section. What happens when you change, or what happens to your license if you change or you leave your firm? Well, let's say you decided to leave your company you're with right now, and you can highlight all these bullets here. You go online and you terminate your license. Now, once you terminate your license with your current sponsoring broker, even though your license is considered inactive because you don't have a sponsoring broker, you cannot sell real estate anymore until you find a new sponsoring broker. Now, let's say that new sponsoring broker's office is right across the street from your current office. So you go over there and you apply for your license, get a 45-day permit, and that will allow you to start selling real estate exactly 1 minute later once you find a new sponsoring broker. But until you find a new sponsoring broker, you are not allowed to sell real estate. Now, if your sponsoring broker terminates you, they go online, they terminate your license. Once they terminate your license, you cannot sell real estate anymore until you find a new sponsoring broker. Now, change of address, name, or business information. Now, the sponsoring broker, if they change their address, change their name, change any information, it's their responsibility to notify IDFPR of the change. Now, you as a licensed broker, if you have a name change, email address change, your home address change, it is your responsibility to notify your sponsoring broker, not your, notify IDFPR. It's not your sponsoring broker's responsibility. It is your responsibility to notify IDFPR if there's a name or address or email change. Now, expiration and renewal, we're on page 269. License expiration and renewal dates are established. Licenses may be renewed by paying the required fees, and you must complete your continuing education. Now, then the next section here is called non-residents and licensed by endorsed process. So we used to have reciprocity with about 8 different states. We do not have reciprocity with them. We do have endorsements, and I'd like you to highlight, there's like 8 bullets here on this page. I need you to go over that. It used to be that if you're licensed in Illinois for 2 years, there are certain states you could go to and just take the state portion and then be licensed, but now you're going to have to take everything. I'm talking about the state and the national again, if you want to be licensed in another state. And if you're going to be licensed in another state, you must have a sponsoring broker in that state. By the way, you can only work for one sponsoring broker in any given state. So you can't work for 2 or 3 sponsoring brokers in Illinois once you're licensed here. Okay, on page 270, they just have the first line. You can always check the IDFPR website for the latest update on reciprocity that we have with other states. Now, about halfway down where it says license fees. Now, initial license fees, I'd like you to go over these bullets here. The one I want you to pay more attention to is the second bullet. To activate a broker's license, the cost is $150. And occasionally, they're going to ask you how it's broken down. So I want to take a moment and explain that to you. So, for a broker to activate their license, it costs $150. How's that broken down? There is a processing. The processing fee, very rare, but occasionally, is $135. Then we have something called a recovery fund, which we're going to talk about at the end of chapter 16 in greater detail. We have a recovery fund, and that's to people who kind of lost money through the actions of a real estate broker. They get $10, a recovery fund. And then we have research and education. Research and education gets $5, and that makes up the $150. Just occasionally they're going to be asking you this, so I just want you to be prepared. Now, let's go on to page 271. I want you to know this, very important. Renewal fees. Now, the cost for a broker, this is on top of page 271. Let's put an X by the second and the third bullet. The cost for a broker to renew their license is $200 per renewal period, which comes every 2 years. I'm going to give you the exact date. Managing broker's license costs $250 per renewal period. So a broker's license per renewal period is $200. Managing broker's license per renewal period is $250. Now you need to know the renewal date. So I need you under license renewal dates. I want you to put an X by where the first one, broker, and then the fourth one, managing broker. Now, a broker's license expires on April 30th of the even numbered years. Broker's license expire on April 30th of the even numbered years. Managing broker's license expire on April 30th of the odd numbered years. You got to know exactly when they expire, including the year. So, and those are the only two I want you to be familiar with. So understand this, both brokers and managing brokers expire on April 30th. Just remember this so you know which one it is. Us, managing brokers, we are odd. You, brokers, you get even with us. Try to remember that. Now, continuing education. I like you to highlight and put an X by the second and third bullet there. Brokers need 12 hours continuing education every 2 years. Now, your first time you're renewing your license, you don't need a 12 hours education because you're going to have that 45-hour post brokers, and then continuing ed will be included in that. But after that, every 2 years, you need 12 hours of continuing education. You don't have to test with the state, you test with the school only. And you're not allowed to take more than 6 hours in any given day. Now, managing brokers, make sure you know this, they need 24 hours of continuing education, and continuing education and no more than 6 hours in any given day. And you cannot renew your license without completing your continuing education courses. And the courses will include things, well, mandatory courses will include things like fair housing. They talk about agency, sexual harassments. Then they have these elective courses. They could deal with commercial, buyer agency. They have a wide range of courses, and they're all very helpful, but you have to do this every 2 years as long as you are licensed. Let's go on to, and the rest of this page you could go over. Let's go to page 272 right now. On page 272, the second paragraph on the bottom of the page, your real estate license, your real estate business, and the act. Place of business. Highlight, put an X by that. Any sponsoring broker that has an active license that opens up an office must have an actual place of business. They must have a office or a storefront, which means that a post office box number is not a real estate office. You got to have an actual office. You must have a sign that's visible from the street, which means putting your business card next to your doorbell of your condo building doesn't mean that's a sign that's visible from the street. You must have an actual place of business. Branch office, that next paragraph, the highlight. If a sponsoring broker wants to open up an additional office, they call it a branch office. They cannot open that additional office until they apply for and receive their branch office license. Now, let's go on to about the middle of page 273. Loss of office manager. I want you to highlight, put X by the first 3 lines. If an office manager, designated office manager dies or quits, IDFPR must be notified within 15 days. 15 days, okay? Now, agency relationship. Now, a relationship's always created between the sponsoring broker and the principal, the buyer or the seller or the landlord or the tenant. Now, you always work on behalf of your sponsoring broker. All the clients, all the buyers, the sellers, the landlords, the tenants, they all belong to your sponsoring broker. You work on behalf of your sponsoring broker. Now, let's go on to page 274. Now, on this top half of this page, I like you to highlight all these bullets here. We talked about this before in chapter 13. We do not have common law here in Illinois. We do not have common law. What we do have here in Illinois is called statutory law. Statutory law says you represent the person you're working with regardless of compensation. That's statutory law. Now, towards the bottom, two things there, where it says section 15-25 deals with licensees' treatment of customers. A licensee shall treat the customers honestly. Customer is the one you don't represent. The one you do represent is your client, and that's the one who you work for. You work with the customer, you work for the client. And the client is one that you have those fiduciary duties that we talked about earlier in the chapter. Do agency disclosure. Do agency, and I'm going to mention this again. If you're working with both the buyer and the seller in the same transaction, that is dual agency. To work as a dual agent, you need signed written consent to work as a dual agent by all parties in there. And understand one thing, working as a dual agent, neither the buyer nor the sellers gain any representation at all. All you are doing is working as a facilitator. Now, designated agency at the bottom of this page, highlight, put X by that. We did talk about that earlier. Designated agency means that when you go out there and get a listing, as I said, all the buyers and sellers belong to your sponsoring broker. So you go out there, you get a listing. Your sponsoring broker assigns you as a designated agent to that seller, which allows everyone else in the office to bring in a buyer, and the sponsoring broker is not involved in a dual agency situation. And if you're working with a buyer, your sponsoring broker assigns you as a designated agent to that buyer, which allows you to find a property that's listed by your own office, and we're not involved in a dual agency situation. Designated agency creates single agency where you're only representing one party only, the buyer only or the seller only. Under, excuse me, under disclosure, what must be disclosed? You can highlight all of this, and there's several paragraphs at the bottom of this page and the next page that I'd like you to highlight as well. Material facts. A material fact is something that will cause someone to make a decision or not make a decision is a material fact. That the basement floods out, that there's electrical problems. Those are material. The property taxes are going to triple. Those are material facts. Material facts must be disclosed. The next bullet, known latent defects. Now, a latent defect is a hidden structural defect. We are not responsible for a latent defect, a hidden structural defect. We are responsible for a known latent defect. If something been made aware of this to us by a professional, now we have to disclose it because we have to be honest with all the customers. Next is the agency relationship. Agency relationship refers to designated agency, dual agency, lack of agency, and compensation sources, which is at the bottom of this page and also the next page on 276. Now, on page 276, about the middle where it says section 10-5, disclosure of compensation. I'd like you to highlight, put an X by that. Real estate agents will stop including shared compensation. The word commission is not going to be shared anymore on the multiple listing service because of ruling that went into effect on August 17th of 2024. So commissions are always negotiable between you and your client, but shared compensation will not be on a multiple listing service. You can ask for compensation, not commission. The word is compensation, and or you have to collect from your own person that you're representing, your own client. Next, the next couple lines over there, you can highlight, put an X by that one. Home buyers working with realtors will require to sign a written agreement, a written buyer agency agreement. That's the law across this nation. You cannot work with a buyer. You cannot show a home to a buyer without having a written buyer agency agreement. You can't even send them information on a listings information sheet without a written buyer agency agreement. So make sure that once you get licensed, you check with your sponsoring broker, get familiar with these forms. I mean, what could happen? You could lose your license. You could get fined very, very heavily for that. So that is a new law. Handling clients' funds. Now it says whenever you receive any earnest money or security deposit, you must turn that over to your sponsoring broker immediately. The law says that all earnest money must be deposited within 24 hours of the next banking day. Your job is to get it over to your sponsoring broker. You don't deposit it in the account. Your sponsoring broker will do that. Next paragraph. The Act states that escrow accounts must be non-interest bearing account. And there's a reason for that. Because if a bank goes bankrupt, non-interest bearing accounts are paid first. If there's money left over, then it goes to interest bearing account. It can go in an interest bearing account if the buyer requests it, but the seller must okay that. So, but that's kind of rare that that would ever happen. It's not going to really amount to much in a form of interest. Now, let's go on to let's go on to the first paragraph here on 277. Earnest money and security deposits must be deposited within 1 business day of the contract or lease acceptance. Not you depositing that money. You must turn it over to your sponsoring broker immediately, because that sponsoring broker must get that money in within 24 hours of the next business date. I would put an X by those very first 2 lines up there. The next line, it says, you can highlight, put an X by that one. It says the act does not limit the amount of escrow accounts sponsoring broker may maintain. Meaning they can open up a separate account for each one of those funds. Or what they could do is put everything in one big account, which is fine, but they better make sure they use sound accounting principles to keep track of everything, which we're going to be coming up to very, very soon. The next line says a sponsoring broker does not have to maintain a escrow account. The escrow accounts have kind of turned into a kind of a big headache for a lot of people. And a lot of brokers do not maintain escrow accounts. Usually it's either the attorney or even the title companies that will handle them. Commingling and conversions. We talked about that before. Commingling means mixing. Number one reason why a sponsoring broker loses their license is that they mix escrow funds with the broker's personal or business funds. They could lose their license, they could get fined. Conversion is basically stealing, taking money that belongs to someone else without their knowledge or permission. Now, if there's a dispute about the escrow funds, sponsoring broker cannot release those funds unless they have signed written permission by both the buyer and the seller. Buyer and the seller only. Let's say a buyer put up $10,000 in earnest money to buy a property, subject to them securing a mortgage. They weren't able to get the mortgage, but so they give the proper notice and they're entitled to get their earnest money back. But an agent will say, well, no, look, I put a lot of time into this. I'm not going to release that $10,000 in earnest money unless you give me $2,000 for my time. Can't do that. You cannot, agent cannot do that. You must return that earnest money long as they gave the proper notices. Now, again, very important, cannot release earnest money unless you have signed written direction of both the buyer and the seller. You know, recently I had a attorney give me a call. He says, I demand that you release the earnest money. I says, I can't release the earnest money on your say-so. That's come from the buyer and the seller. He says, I'm the attorney, and I'm the one that's making that decision. I go, well, Mr. Attorney, according to the state law, I cannot release that earnest money unless I have signed written permission by both the buyer and the seller. And that's all there is to it. Now, if there's a dispute among the buyer and the seller and they can't agree to release the earnest money, well, the sponsoring broker cannot hold on to this earnest money forever. If they can't resolve it, they tries to resolve it, they can't, then after 6 months, they could turn it over to what's called an interpleader, which is the state, and let them settle it with them. They have to divest themselves of this issue. Now, we're going to take a quick break here, and I'm going to finish the other half of this chapter when I get back. So, because I'm breaking this down in two portions here. So I'm going to be talking about escrow records, and I'm going to finish up chapter 16. We're on page 277. I'm going to finish that up on the next session. So again, until then, check with you have any questions, talk to your instructor, or if you need to, you can email the school and they'll forward that to me, and I'll make sure I answer any questions that you have. So until I see you on the next session, just have a good time and keep up with your studies and the chapter quizzes. Okay, thank you. Okay, hello, CRES students. This is Sam Zakarian. This is our final video session. It's a continuation of chapter 16. We're using the 10th edition again. Now, the second part of chapter 16, we left off on page 277, right about the middle of the page. I ended up with talking about escrow and disputes of escrow and disbursements. So right in the middle of page 277, now we're going to talk about escrow accounts. So that first couple lines there, this is right in the middle of the page. It says, each sponsoring broker that accepts earnest money for any transaction must have a bookkeeping systems with sound accordance with accounting methods. Not every sponsoring broker needs to hold escrow accounts, but the ones that do, they have to keep certain records. The first thing I want you to know about, where it says a journal, highlight, put an X by the next couple of lines there. A journal must be maintained for each escrow account, and the journal shall show the chronological sequence of funds received and dispersed. You can go over those bullets at the bottom of page 277. Let's go to page 278. Also, at the very top, a ledger. Highlight, put an X by those three lines. A ledger shall be maintained for each transaction. Ledger shall show the receipt and disbursements of funds affecting a single particular transaction. You can go over these set of bullets underneath there. So a little bit past halfway down, still on page 278, I mean. Monthly reconciliation statements, the first two lines likely want you to highlight, put an X by. Sponsoring brokers who maintain escrow accounts must balance their accounts within 10 days of receiving a bank statement. Make sure you understand that. Bank accounts must be reconciled within 10 days of receiving the bank statement. And then the very next paragraph, you can highlight, put an X by that one. Sponsoring brokers who hold earnest money or security deposit must have a master escrow account log. The master escrow account log will have a list of the name of the bank, the financial institution where the escrow funds are kept, the name and address and the bank accounts, all that's going to be on the master escrow account log. Now, let's go on to page 279 in your textbook. Again, we're working with the 10th edition. Near the top where it says licensed acting assistants, they talked about unlicensed assistants and licensed assistants. Now, we talked about this before. Now, top producing agents who might hire a assistant to help them with their business. There are two types of assistants they can hire. One's called a licensed personal assistant. The other's called a unlicensed personal assistant. Now, a licensed personal assistant will be someone that has a broker's license, but instead of doing business on their own, they're working for another licensed broker. Now, let's say that you are a licensed real estate broker, top producer, very, very busy. You hire me to be your personal assistant. I'm a licensed real estate broker as well. Now, since I'm licensed, I could do anything you could do. I could show properties. I could host the open house, interpret contracts, and negotiate contracts. I could do anything you could do. As far as you paying me, well, you could pay me an hourly rate. You could pay me a flat fee. You could pay me a percent of the commission, but it can't be paid directly from you to me. Since I'm licensed, all licensed brokers must only get paid by their sponsoring broker. So whatever you're going to pay me, you pay our sponsoring broker, who then will pay me. Now, if I happen to be unlicensed and I'm working for you, now what happens is that I'm very limited as to what I could do. Being an unlicensed personal assistant, I could only do clerical type work. I could answer the phone, I could take messages, assemble documents, file papers, design flyers, clerical type work only. What's more important is what I cannot do since I'm unlicensed. Cannot show property, host an open house, interpret contracts, and negotiate contracts. I cannot do anything that a license is required. Now, as far as paying me, you can pay me directly, but it can only be flat fee or hourly rate. Cannot be a part of the commission, because to collect any part of a commission, you must be a licensed real estate broker. Now, right in the middle of the page here, we're still on page 279. We're talking about blind ads. Blind ads are illegal. Blind ads are illegal, meaning that any type of advertising that you do, you must have the broker's business name in all ads. Doesn't matter if you're advertising in your church, your billboard, your website, your business cards. They all have to be must have your sponsoring broker's business name in all ads. And just remember one more thing: your name cannot be larger than your broker's business name. Now, let me give you an example of a blind ad. Let me get to my chalkboards just so that you understand this. Get my pen out. All right, here's an example of a blind ad. This is my ad. For sale. It's a 4-bedroom, three-bath, located in Skokie. It's my ad. Call Sam. Did I put my number over here? This is a blind ad. I must have my broker's business name on all ads. Blind ads are prohibited. Now, towards the bottom here on page 279, ads prepared by licensee should at least include, and you can highlight and put an X by these next 4 bullets: the property for sale, the licensee's name, the company's name, and the city or the area of the advertised property. And all other ads, put an X by the very last bullet on 279. The licensee's name, let's go to page 280. The very first bullet, you put X by the company name as registered with IDFPR. Now, the next section, this is near the top of page 280, a licensee must, and put an X by these next 5 bullets, never advertise in only his or her name, always include the firm's name and address, never advertise another sponsoring broker's listing without written permission. Next bullet, always keep advertising up to date and clear. And then the last bullet, never create ads containing inherently misleading terms, like under your name, like company or realty, real estate agency, etc. 2 paragraphs down, social media and text. Yeah, I would highlight the next 4 paragraphs there. Now, social media is just a wonderful way of getting in touch with thousands of people just by hitting a button. You should, I told everyone, I believe I said this in the very first video, this is a people finding business, and it's important for you to contact as many people as you know to let them know that you're in a real estate business. On your social media, you got putting content in there, your blogs. They have to be things that are interesting that other people will pass on to others. That's how you're going to increase your business. So, now, the next section, licensee advertising by way of internet or other forms of electronic media are forbidden to, you can highlight these next 3 bullets, employ deceptive or misleading URLs or domain names, frame the website of another real estate brokerage or a multiple listing without written permission, and using keywords or other such tools as to mislead consumers. Now, advertising on the internet, the last 2 bullets you can highlight. Internet must include the proper identification, licensee's name, company name, location, things like that. And then e-correspondence, bulletin boards, e-commerce, discussion groups, required licensee's name, company name. So you got to make sure you always put in your company's name, your name, contact information, location of the property. You can highlight these. We're on page 281, the very first 2 bullets here. You can highlight the very first 2 bullets. Links to listing information from other internet sites are permitted without approval unless the website owner requires approval. And then, as with other advertising, internet sites are to be updated periodically and kept current. Now, this next section here. In internet advertising situations, the rules do not allow advertising a property that is subject to an exclusive listing agreement with the sponsoring broker and failing to remove advertising of a listed property within a reasonable time. Now, the next few paragraphs, you can highlight them, painting a true picture. You've got sometimes real estate agents, they get very creative, with their computers and describing property and what they do is they add things into it. Now, if you're going to stage a property, it's an empty house or something, and you're going to stage a property, that's fine to do so. But you got to make sure that you disclose that this property is currently staged. Some people will, just change the scenery completely. They add in windows when there are no such thing. Or if you look out the window, they show beautiful view of the park or the lake when there isn't one. So you got to paint a true picture. You can't deceive the public is what we're saying over there. Now, selling your own property. The last couple of paragraphs you can highlight, put an X by. We go to page 282. That very first paragraph and those 2 bullets underneath there, I want you to highlight, put X's by that too. Now, if once you're licensed and you're going to sell your own property, if you're going to do a for sale by owner, for example, then on the sign itself and your advertising, your website, your flyers, whatever you do, you must state that the owner is a licensed real estate agent here in the state of Illinois. We have more knowledge than the general public, and we must make them aware of that. So you can lose your license. You could get fined $25,000 if you don't. So always disclose that you're the owner. Now, if you happen to be selling your own property on a sales contract, when you sign the sales contract and the disclosures, you got to write this down on the contract itself, that the seller is a licensed real estate agent in the state of Illinois. Or if you're buying property once you're licensed, you have to disclose that the purchaser is a licensed real estate agent in the state of Illinois. We have more knowledge than the general public, and we must make them aware of that. So try not, just don't deceive. You can't deceive people. Now, compensation and business practice. There's a set of bullets on this page, and I believe there's a few more on the next page as well, or one more on the next page. I need you to highlight and put an X by all of these. Now, these are very important, well, everything's important, but these are especially important. So I'm going to go over each one of these with you. So the very first bullet, now we're near the top of page 282. Compensation in a business practice. First bullet, section 10-5. You don't have to memorize article numbers or section numbers. I'm just using these for reference right now. States that a licensee may not receive compensation from anyone other than his or her sponsoring broker. So you can only get paid by your sponsoring broker. The only exception to that will be you sold a property and went under contract, but it didn't close yet. Yet you left that firm and you joined another sponsoring broker. Well, since you earned it under the first sponsoring broker, that's the one and only time you could get paid by someone other than your sponsoring broker. Next bullet. Sponsoring brokers may directly compensate other sponsoring brokers, like in a cooperative compensation agreement that they're working with. The next bullet, section 10-10. Disclosure of compensation is a significant issue. Whatever you're going to be charging your buyer or the seller, and how much of that's going to be shared with other cooperating brokers, must be in writing. All those things are included in an exclusive listing agreement or exclusive buyer agency agreement. The next bullet. If compensation is being issued to an agent from both the buyer and the seller, the same transaction, then this must be disclosed in writing. Not that you need permission, you just need to let them know. Your buyer's willing to give you a commission, you get collecting a commission from the seller, as long as it doesn't exceed what you agree your buyer will pay. Always talk to your managing broker to clarify that. Next, if a licensee refers a client to a service which the licensee has more than 1% ownership interest, that must be disclosed as well. I want you to use this law firm. I want you to use this home inspection company. I want you to use this mortgage company. If I own more than 1%, I have to disclose that I'm one of the owners. Next. 1 second, I lost my spot. Section 10-15. It is illegal to compensate anyone that's unlicensed or anyone else being held in violation of the act. So you cannot pay anyone that's unlicensed any part of your commission. Now, there is one exception to that, and that's going to be coming up just in about another minute, and I'll explain that to you. Next bullet. To sue for a commission in Illinois, one must be a real estate sponsoring broker. Why? Because the buyers and sellers only belong to the sponsoring broker. You work on behalf of your sponsoring broker. Next bullet. And remember, you have access by all of these. Funds from sellers or buyers always go through the sponsoring broker, because he or she is the only one who issues compensation to brokers, managing brokers, residential leasing agent, and licensed brokers working as personal assistants. Next bullet. No licensee may pay a referral fee to an unlicensed person who's not the principal of the transaction. Again, you cannot pay any part of your commission to anyone that's unlicensed, except unless they happen to be a principal to that transaction, meaning they're the buyer or the seller. Being the buyer or the seller, you can offer gifts, you can offer a portion of your commission. You are allowed to do that. Only if they're the clients, the buyer or the seller in that particular transaction. Next bullet. Section 10-15 states that licensees may offer cash prizes, awards, coupons, merchandise, rebates, chances to win a game of chance, as long as it's not prohibited by law. And then the last bullet here on this page, it's now legal for a sponsoring broker to pay a corporation set up by that licensee. Licensees can set up a corporation for only one purpose of receiving compensation, their commission. They must sell under their own name. They cannot sell under that corporation name. It's only for, tax purposes of receiving compensation. Now on page 289, let's go to page 280. I'm sorry, 283. I apologize. The very first bullet is still a continuation of that. I'd like you to highlight, put an X by that very first bullet. The law allows formation of an entity to receive compensation from the sponsoring broker, as long as the sponsoring broker or the owner and an unlicensed spouse are the owners of the entity, so they could pay their entity. Now, this is disciplinary provision and loss of license. I like to highlight and put an X by these next 5 bullets. On the next couple pages, I'm going to go over the violations of licensing laws and how you could lose your license or get fined, get suspended, get reprimanded. There's on the next few pages, there's several of them. Now, I'm going to go over all of these with you. I'm going to go over all of them with you. A lot of them pertain to the sponsoring broker, but you must be aware of these on the state exam. So those next 5 bullets I told you to highlight, put an X by. If you violate any of these rules here of the license laws, what could happen? They could impose the following penalties. That first bullet. They could refuse to issue or renew a license. The next bullet, they could suspend or revoke a license. Next bullet, they could censor or reprimand a licensee. Next bullet, they could place a licensee on probation. And make sure you know this one. You could get fined up to $25,000 for any one offense or combination of offenses. Now, causes for discipline. Like I said, I want you to highlight all of them on this page, the next page, and the following page as well. Some of them, I'm going to have you put an X by, only because they just apparently show up a little bit more often on a state exam than others. So that first bullet under causes for discipline. And this is how you can lose your license. You make a false promise or fraudulent representation in attempting to obtain or renew a license. For example, if you lied about you completed your continuing ed, you could get fined, you could lose your license for that. The next bullet, if you've been convicted of a felony or a crime involving dishonesty, fraud, larceny, embezzlement, obtaining money or property by credit or false pretenses, or by means of a confidence game, anything that involves money, even if it happened in your past. Next bullet, if you're unable to practice the profession with reasonable judgment and skill as a result of a physical injury. The next bullet, practices as a licensee in a retail establishment that's not separate from the retail business. So you cannot have a real estate office in a retail business store, in a department store, or even in a bank, unless it's separate and distinct entrance. Next, if you've been subject to disciplinary provision, this one I put an X by this one. And let me finish reading this and let me explain it to you. If you've been subject to disciplinary action by another state, District of Columbia, territory, foreign nation, government agency, or any other entity authorized to impose discipline, if at least one or the grounds for that discipline is the same or equivalent or effective license. Let me explain what that is. I'm sorry. It's say you've been licensed in another state. You've been licensed, let's say, in the state of Kansas, and as a licensed real estate broker, you did something wrong over there and you lost your license. Now, the reason why you lost your license in the state of Kansas is the same reason why you can lose your license here in Illinois they can refuse to issue or renew your license here in Illinois. That's what that paragraph meant. Next bullet. Attempt to subvert or cheat on a licensing exam or assist anyone else in doing so. Now, you're being videotaped when you take the state exam. Do not talk to anyone. Besides that, the person next to you doesn't have the same exam as you. You know, all the questions are all mixed up. Now, if someone starts asking you questions, you tell them, look, I'm taking a test, don't talk to me. If they ask again, you need to go and tell the proctor. Do not assist anyone. Do not respond to anyone while you're taking the test. Because otherwise they could say they'll fail you and they could refuse to allow you to take the test again. Next bullet. Advertising in a way that's inaccurate, misleading, or contrary to the provision of the Act. Now, continuing. A licensee is also subject to disciplinary action if found guilty of any of the following activities. First bullet, making any false promise to influence, persuade, or induce. Just like lying to people, telling clients, oh, if you buy this property, I'm positive it's going to go up in value by 20% by next year. You can't do that because no one knows that. Next bullet. Pursuing a continued frequent course of misrepresentation, making false promise through licensees, employees, agents, advertising, otherwise. Next, using a trade name or insignia in a membership in a real estate organization if you're not a member. For example, you can't use the word realtor behind your name unless you happen to belong to the National Association of Realtors. Next bullet is I will put an X by this one. Acting for more than one party in the same transaction without written agency disclosure. We're talking about dual agency. Next, representing or attempting to represent a broker other than the sponsoring broker. You can put a X by this one. Failing to account for or remit any monies or documents belonging to others that come into the licensee's possession. Handling earnest money checks. Earnest money checks got to be turned over to your sponsoring broker immediately so they get deposited in their account within a lot of time. Page 284, very first bullet. Failing to properly maintain and deposit escrow accounts in a separate account. Again, this is information that the sponsoring broker does. This is the duty of a sponsoring broker. I'm just mentioning this to you so that you're aware of this. Because you will see some of these on the state exam. Next bullet, failing to make all escrow records maintained in connection with the practice of real estate available during normal business hours and within 24 hours of a submitted request. So again, sponsoring brokers have to keep all escrow records, contracts, ICA agreements available at all times. IDFPR can walk into any real estate office unannounced at any time. They have to have 2 years worth of records on hand. With a 24-hour request, they have to produce 5 years worth of records. Now, the records can be kept electronically or hard copy, it doesn't matter. But sponsoring broker, if they're going to keep it electronically, they got to make sure they back it up on a regular basis. They can't say, well, I have 5 years worth of record and my computer crashed and I'll have no records. No, that's not gonna work. In fact, put an X by this one, as I mentioned just now. Failing to keep all records for 5 years electronically must be backed up. Next, failing to furnish on request copies of all documents relating to real estate transaction to all parties executing them. Put an X by this. Maybe I would write this down. Whenever anybody signs any document, you got to make sure they get a copy of what they signed within 24 hours. 24 hours. Next bullet. Failure of a sponsoring broker to provide appropriate licensing documents, license termination information in a timely way. Next bullet. Engaging in dishonorable, unethical, unprofessional conduct of a character likely to deceive, defraud, or harm the public. We have to protect the public. Put an X by this one. Co-mingling the money or property of others with one's own. I mentioned this, actually, this is going to be at least the third time. Commingling is the number one reason why sponsoring brokers lose their license here in Illinois, is where they mix escrow funds, funds that belong to others, with the broker's personal or business funds. Next bullet, employing any person on a purely temporary or single deal basis as a means of avoiding payment to a non-licensee. Next, permitting the use of one's managing broker's license by another person to operate a real estate office without their participation. They can't do that. Put an X by this one. Displaying a for rent or for sale sign on any property or advertising in any fashion without written consent of the owner. Now, in order to put up a for sale sign, in order to host an open house, in order to put a property on a multiple listing service, in order to advertise a property on the internet, you need signed written permission by the owner to do so. But all of that permission is granted in the listing agreement. Next bullet, failing to provide information requested within 30 days of the request as it relates to audits or complaints made against a licensee based on the act. Meaning, if IDFPR ever contacts you and they want some information, whatever they request from you, you need to respond to them. And the quicker you respond to them, the better off you are. You can't ignore them whatsoever, not at all. Next bullet, utilizing blind advertising. You can put an X by that one. Remember, not using here, right on the screen right here. For sale, 4-bedroom, 3-bath, Skokie, cost Sam. I'm not using my broker's business name. That's a blind ad. Blind ads are illegal. Next, offering a improperly constructed guaranteed sales plan that does not meet the actual requirement for such a plan. Actually, we're going to get to that in more detail in about 5 minutes, and that's going to come up in a couple of pages. I will cover that for you. Next bullet, intending to promote racial and religious, put an X by this one, intending to promote religious or racial segregation by use of actions or words or behaving or speaking in such a way as to discourage integration. Put an X by the next one, violating Illinois Human Rights Act. Cannot discriminate under all the protected categories. We already discussed that in chapter 14, but including Illinois. Next one, inducing any individual to break out of put an X by this one, I'm sorry. Inducing any individual break out of an existing contract and enter a new one, whether sales or listing contract. Let's say, because sometimes the market's going very well, very hot, and the property sells in a matter of a day or two. Sometimes an agent will call up another agent and says, let me ask you something. Was that your buyer that bought your listing? No, it wasn't. It was from another company. An agent will say, what if I told you that if you break that contract with the other agent and let my client bring in a contract, I'd give you, a couple $1,000 or something like that. Well, the answer to that is, well, just by suggesting that to me, not only could they lose their license, but they could get fined $25,000. So where do you want to go from this point on? Put an X by the next bullet as well. Negotiating directly of a client of another agent, with the client of another agent. If I have your home listed for sale, anyone that has any offers, they must go through me because I'm the one that's representing you. You can put X by this one. Acting an attorney in the same transaction when one is a real estate licensee. You cannot be an attorney and a real estate licensee in the same transaction. You cannot be an appraiser and a real estate agent on the same transaction. You are allowed to be a loan officer and a real estate broker in the same transaction. The next bullet, actually, bullet looks like it's missing, but if merchandise or services are advertised for free, any conditions or obligations necessary for receiving the merchandise or services appear in the same ad or offer. Let me explain that to you. You're running an ad, list your home with me, and I'll give you an 80-inch flat screen TV. Well, in order for you to get that 80-inch flat screen TV, Not only do you have to list your home with me, but it has to be listed at $1 million or more, must sell and close in the next 30 days for cash. Otherwise, you don't get that TV. See, any conditions of receiving the merchandise must appear in the same ad. Next by this next one, disregarding violating the provision of the Land Sales Registration Act or the Timeshare Act. So let me go over that again with you. Timeshare Act. Anyone that sells a timeshare in Illinois, regardless of where it's located, they must be licensed real estate broker. And then the Interstate Land Sales Registration Act. If you happen to sell vacant land located out of your own state, not in your state, out of your own state, when someone signs contract to buy vacant land, they must get a property report at the signing of the contract. Now, if they do get the property report at the signing of the contract, they still have 7 days to cancel the contract and get their money back. If they don't get the report, they have 2 years to cancel the contract and get their money back. Things that are going to be on the property report, if there's any liens, what the zoning is, what you're allowed to build, any restrictions. And remember, I talked about this already, percolation test. Percolation test is required if they're going to locate a septic tank, and that's only required if they don't have public sewer systems. Next bullet, violating a disciplinary order by the state. If they tell you to cease and desist, you can't practice real estate, you must obey their rules. Next, paying or failing to disclose compensation that violates the act. Next one, disregarding violating any provision of the act or published rules or regulations promulgated to enforce the act. Next bullet, failing to provide minimum services required under an exclusive brokerage agreement. Any exclusive brokerage agreement with the buyer or the seller, you have to provide minimum services. Those minimum services include that you have to present any and all offers, communicate with your client on a regular basis. That's the most important thing. We've discussed that already. Now, next one, the last bullet here. Violating terms of a disciplinary order issued by the department. Now let's go to page 285. There's a few more up on the top. You could highlight those. Yeah, I can put X by the very first one here on 285. Forcing any party to a transaction to compensate the licensee as a requirement for releasing earnest money. Let's say a buyer put up $10,000 in earnest money, and the buyer had a contingent upon securing a mortgage, wasn't able to get the mortgage. He gave the proper notice. The buyer's entitled to get that $10,000 earnest money back, the full amount. But the agent might say, well, look, I put a lot of time into this and I want to be compensated. I'm not going to release that $10,000 unless you give me $2,000. Can't do that. Just can't do that. You got to release the entire $10,000 or whatever the amount is of earnest money. This next bullet, habitual use or addiction to alcohol, narcotics, stimulants, or any other chemical agent that results in a licensee's inability to practice with skill and safety. Next bullet, failure to disclose the licensee status on a multiple listing service data form that's accessible to the public, that you have any ownership interest in this property. Always have to disclose. Now, discrimination, 2 paragraphs down, highlight, put an X by that one. If a licensee is found guilty of discrimination, automatically their license must be suspended or revoked. Automatically. You'd probably be in jail anyway. Guaranteed sales plan, like it, a highlight, put X by that paragraph. Like it, a highlight these 5 bullets at the bottom of this page. Now, a guaranteed sales plan, you know, there are companies, there are agents even, that say, if I don't sell your home, I will buy it. That's a guaranteed sales plan. Now, if someone's going to offer a guaranteed sales plan, they have to disclose all the conditions of a guaranteed sales plan. But let me just give you a rough idea of kind of how it works. If I'm offering, if I don't sell your home, I will buy it. Well, first of all, we get an appraisal done. You're going to pay for the appraisal, the homeowner. Get an appraisal done on a property. And then what we do is we list it at that appraisal price for a year. If it doesn't sell in a year, then the agent can buy it, but not at the appraisal price, usually at 30% less than the appraisal price. Now, in the meantime, they have to try to market the property as they would any other property. I'd like you to read that over, especially those bullets, and make sure you understand that. Now, on this next page here on 286, I like you just to go over that. They talk about the requirements for formal hearing, disciplinary proceedings. I like you just to really just go over all that so you understand that stuff. Let's go on to page 287. On page 287, the top part, it's again, I like you to review that on your own. But now, the last two paragraphs of 287, I want you to put X's by both of these. Non-payment issues when obtaining a license. Non-payment for child support. X by that. If you are behind on child support, IDFPR could refuse to issue or renew your license. Non-payment of state income tax. If you are behind on Illinois revenue taxes, I mean, if you have a payment plan, that's fine. But if you have not paid your Illinois revenue taxes, they can refuse to issue or renew your license. On the very first paragraph on page 286. If you are behind on Illinois student loans, a university from Illinois, and you're behind on Illinois student loans, it doesn't matter that you have outstanding payments, you're making your payments, but they can refuse to issue or renew your license. Now, the rest of this page here on 288, I'd like you to go over that on your own. And let's go on to page 289. Now, the third paragraph down where it says the Real Estate Recovery Fund. I like you to highlight, put an X by that. There's a bunch of these bullets underneath that paragraph. Highlight, put an X by all the paragraphs here on page 289. Also, highlight, put an X by all the paragraphs here on page 290. This all deals with recovery fund. And highlight, put an X by the last page on 291, the last two lines. Highlight, put an X by that as well. This is called the recovery fund. Now, the recovery fund is created if anyone has been aggrieved by real estate licensee, monetarily aggrieved. I'll explain that in a moment. They have options where they can collect from the recovery fund. Now, the maximum you could get for any one act cannot exceed more than $25,000. For any one act, cannot exceed $25,000. Now, you can only collect actual money loss. No pain and suffering, just financial losses is all you could collect from the recovery fund. Now, I'm going to give you an example of some things that I want you to be familiar with. You listed your home with me. And here's what happened. On the first day, day number one, when you listed your home with me, I did something wrong. Because of my actions, you lost $150 on it. Day two, I did something else wrong as your real estate agent. Because of my actions, you lost $1,500. Day number three, I did something else wrong. This is three. Because of my actions, you lost $15,000. Day number four, I did something else wrong. Because of my actions, you lost $150,000. Day five, something else wrong. Bad real estate agent. Because of my actions, you lost $300,000. Now, question is, what can you collect from the recovery fund? On day one, you lost $150. That's all you could collect. You can only collect actual money loss. Again, there's no pain and suffering. You lost $150. That's all you could collect for that day. Day number two, I did something else wrong. Because of my actions, you lost $1,500. So that's the maximum you could collect for that. Day number three, because of my actions, you lost $15,000. So the maximum you could collect is $15,000 for that one act. Day four, I did something wrong, and it costs you $150,000. The maximum you can collect is $25,000, because for any one act, the maximum you can collect is $25,000. Day five, I did something else wrong. One thing I did wrong. You lost $350,000. Well, the maximum you can collect for that is, again, $25,000. Look what happened. I did all these things wrong, and you lost over $516,000. You lost. The maximum you're going to collect is a little bit over $66,000. That's how that is. Just make sure you understand that. Now, I'm not done with this. Now, in order to collect from the recovery fund, it's all those things I told you to highlight and put an X by. So make sure you read every single line of that. In order to collect from the recovery fund, you must take me to court. You must win the court case. You must attach my personal assets. You must allow me to exhaust all my appeals. And then this all has to be done in a 2-year period. Again, in order to collect for the recovery fund, you must take me to court, sue me in court, win the court case. You must win the court case, attach my personal assets, allow me to exhaust all my appeals, and this all has to be done in a 2-year period. Now, the recovery fund is only allowed to keep $750,000 in there. Anything above that amount has to be turned over to the state. I told you to highlight and X off everything on a recovery fund. I just explained everything to you about the fines and what's the requirements, but please read this on your own. I want you to be a little bit familiar with it. And just one quick other reminder, every time that anyone activates their license, $10 of that goes to the recovery fund. And again, that means the recovery fund, if anyone's been financially hurt by a real estate licensee, they can't collect money from the recovery. That is the end of our session lectures. There is another video on Appendix A, which is on the math. There's 25 math problems on there. So you need to make sure you go over the math. You get 10 math questions on the state exam. Don't know which ones you're going to get. That should cover pretty much everything. Now, just one last thing I want to say. Let's say you're scheduled a week from today to take the state exam. You completed all the chapter quizzes. You met all the requirements of the classroom requirements. So, and you're not scheduled to take the test to a week from now. Every day, I need you to pick up that book. I'll need you to spend, I'm not talking about 8 hours a day. Spend an hour and a half a day just reviewing, keep the stuff fresh in your mind, and take the state exam as quickly as possible. Just a couple other minor tips is that make sure the best thing you do before you take the state exam is get a good night's sleep. Get a good night's sleep. Because if you don't know the answers 12 hours before you take the state exam, guess what? You don't know the answer. And guess what? Staying up all night cramming is not going to help. You need a fresh head. Take your time. You have 3.5 hours to take the test. Take your time, read the questions carefully. Make sure you read all 4 answers before you pick out one. But it could be 2 good answers. Well, one is better than the other. So make sure you read all 4 of them. And do not, I'm going to tell you something, been doing this for a while. Do not change any answer to any test question unless you're absolutely sure it's wrong. 90% of the time, or at least 80% of the time, people have the right answer, but they second guess themselves. You can come back to any questions, that's fine. They ask you once you answer it, or even if you don't answer it, you want to come back, you can. Don't try to go over every single question. Okay, don't try to go over every single question, because after you answered 150 questions, your mind just turned into a big bowl full of jelly, and then you're gonna start second guessing yourself. You don't need to do that. So always go with your first instinct. Again, this is Sam Zakarian, the instructor for one of the instructors for Chicago Real Estate School. I look forward to maybe working with you in the future. You have any questions, always talk to your instructor, or you can always contact the school. They'll notify me and I'll answer anybody's questions. So again, good luck to all of you, and I wish you a very successful career in real estate. Thank you very much.